Okay, looks like we're ready. You guys all ready?
Ready.
Ready? Good evening. Welcome to the August 12th, 2025 Murraysville Plan Commission meeting. Please all rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Patty, please call the roll.
Mr. Midal?
Here.
Mr. Kearns?
Here.
Mr. Patrick?
Here.
Mr. Olszewski? Mr. Lemke?
Here.
Mr. Levecki? Here. Mrs. Hoy?
Here.
Mrs. Ling?
Present.
Okay, we have minutes from July 8th, 2025. Is there any comments or corrections to the minutes as presented?
No, Mr. Chairman, I make a motion that we accept the minutes as presented.
Second?
Second. All those in favor say aye.
Aye.
Okay, we have a period for public comment on the agenda. Does anyone have anything they wish to bring to the attention of the Planning Commission that is not on the agenda this evening? Which you all have an opportunity to speak at that time. No? Okay. We have two public hearings this evening. There's a court stenographer. Way we generally run the public hearings, we allow the applicant to give a brief presentation, followed by questions from the planning commissions or comments, and then I'll throw it open to the public. Please keep in mind there's a lot of people here tonight. I know everybody wants to say something, I would think, other than it's just hot outside and you didn't have any place better to go. But please keep your comments to under 2 minutes if you can. Ryan, would you please swear in anybody that wants to give testimony?
Anybody that's going to speak, please rise and raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Thank you all. Okay, the first one is public hearing Z225. This is Murraysville Enterprise rezoning concerning the rezoning of 3 acres of land. This is land parcel 4911000129. This is from R2 medium density, or from PEL, from public land to R2 medium density residential. Is there someone here representing the applicant tonight?
In the back, Bob.
Yes, sir. Could you come forth and give us a little presentation of what you want done?
Murraysville is the applicant for the rezoning?
Yes. Murraysville Enterprises?
Yeah, this is the one that we kind of took the lead thinking that this may have been a
Okay.
map error.
I'm sorry, I got confused. I saw all these smiling faces out here before. Mike, would you please give us a dissertation on what this is all about?
Of course, Mr. Chairman. So the landowners approached us a few months ago. They did not know that this was zoned PL public land. We scoured our records. We looked on the county website, everything that was available. We could not find anything. There's no ordinance deeding it over as public land. There's no deed of acceptance. There's nothing that we could find. But I will say within the past week, we have had a couple things come up that have filled in the picture a little bit. So I did have everything in the Dropbox for you all. We may need another month to look over this kind of stuff, maybe get some legal advice, but I leave it up to you guys.
Well, it's my understanding that when this was approved, in 1989?
So the subdivision itself, and I can see if I can get this map up to try to kind of demonstrate.
In 1976, is that what I was saying?
1976 is what I thought.
Yeah, so this is the parcel in question right here. Sorry, let me get this closer. When this was subdivided in 1976, this was set aside as a separate lot that was never to be subdivided any further. When this housing plan was approved in 1989, they offered up this as green space. I have the Parks Commission meeting minutes from May 2nd, 1989, where they discuss that, Planning Commission, where they discuss it, and then finally the council meeting minutes where it was approved. It was to be set aside as green space. There's some discussion of deeding it to the municipality, but there's never a response to that question. So as far as I can tell, it may have been set aside as green space, but there is also covenants that run with the land that expired on January 1st, 2000. And if you have looked at any of the meeting minutes in there, they reference that as a cutoff date. So it's a little unclear. That's why we may need a legal opinion on this one.
I think you're probably right. We will need a legal opinion on it, but there's a question as to whether or not the covenants expire in 2000, and therefore this could be a building lot since it's zoned properly and was never turned over to the municipality.
Correct.
Who owns it now, or who claims to own it?
Murraysville Enterprises is who.
Murraysville Enterprises, okay. All right. Does everybody understand the issue here?
A little foggy. If it was supposed to be green space associated with the plan across the street, would it not remain in the name of the plan developer?
That's who it is.
Yeah.
Murraysville Enterprises.
That clears it up a little bit for me. Okay.
And any restrictions in the covenants that affected that property are now expired, so
Correct.
should be buildable.
Okay. I'm sure there's some,
What's the floodplain there?
no idea.
Well,
I would say a
I'd take a look.
good chunk, maybe about up to here, is in the floodplain.
I know that there, are there any other
No.
members of the planning commission make comments or questions? Okay, we'll try to do this in some orderly fashion. Start over here on this side. Saw some people I thought were interested. Could you give us your name and address, please, sir?
My name is Jason Leist, and I live on 349 Hills Church Road, and I'm right adjacent to the road access of the lot.
Okay.
I'm on the left side. So first of all, thank you so much for letting all of us participate in this process. And it's a complicated, very difficult issue, and appreciate just the honesty and candor of just obviously there's been some things that have been missed or some sort of misunderstanding, and appreciate trying to make that right. I think if a mistake was made in any regard that led to this and led to us being here tonight, of course, appreciate how that affected Murraysville Enterprises, the owner of this property, adversely affected them. I think it's important just to recognize that they're not the only party that this could possibly adversely affect. My family, other families that have purchased homes with the understanding and with this lot being marked as park land that we assumed meant it was public land owned by the municipality. I purchased our home in October of 2020. It was marked as parkland then. Had an attorney that helped me purchase my property. He at no point let me know that there was a residential lot there that was unoccupied. That would have been information I would have certainly liked to have known before I purchased this property. Certainly purchased my property thinking that this was parkland. I thought public land. My family, my children have certainly used it for those purposes. So I think it's important to acknowledge that and let that be on the record that this is affecting a lot of people and has possible adverse effects for that reason. To that said, I would just respectfully encourage the municipality to really take time to really get to the bottom and try to really find hard evidence about what exactly led to this, how this happened, why it happened. I think that's really important for everybody involved for a lot of different reasons, regardless of how this mistake may or may not be made right. I want this on public record too. responsibility to tell you what I know from living on this land for 5 years now, next to it. The flooding is very severe on this land. Actually was able to obtain a flood map with the floodplain and the flood zone. It goes right in the middle of what I suspect is the buildable part of this land, which seems to me, in my opinion, would suggest that this is not buildable land and probably should not have permanent structure built upon it of any means. I don't know what possible liability there could be there, safety concerns. I don't know a construction company or insurer would want to insure a property, homeowner would want to live on a land with flooding multiple times throughout the year, including the winter time. So just anecdotally, from my experience in living there, I can give testimony that it does flood frequently throughout the year. For that reason, does not seem to be reasonably buildable. Thank you very much. And
Thank you for your comments.
if I can at any point be helpful in this process, please let me know.
Appreciate it, appreciate it. Michael, could you dredge up the the FEMA maps for this area?
Yeah,
I think that's a very good point the gentleman made. All right, continuing on back through on this side, anyone else?
Hi, good evening. My name is Ben Carter, 3415 Hills Church Road. I live 2 doors down from Jason. My family and I, we moved here in April of 2021 from Edgewood, so we saw this kind of flat, wide open space. We love the yard. One of the main reasons why we lived, why we purchased the lot there and the house was mainly for the yard. We have 3 small children. And if we knew that this was residential land or parkland, doesn't really make much of a difference to us. I don't think that would have changed our decision purchasing the house. But we enjoy having that space back there. I would attest to what Jason just said. June 6th of this year, we were out there, and I think the waters came up farther than we've ever seen them come up before. And so much so that we had some chairs and a bench that was taken down to the Shevchik's house, which is across the creek, actually. And I think the flooding may be getting worse as there are new developments and houses put up in Murraysville. I think people that have lived here longer than I have could attest to that. And just about the confusion with when this was parkland, when it was supposed to be parkland. It's an unfortunate error. I don't blame any present company here. It would be helpful to clarify this for the neighbors' part, for our part, for Murraysville Enterprises, just to understand, just to clarify these matters. But thank you for letting us speak and bringing this issue up. We appreciate it.
Thank you for your comments, sir. Anyone else on this side?
Hi, my name is Larry Ellman. I live at 3443 Hills Church Road. I'm here with my wife. We lived in Hills Church Road home for nearly 9 years. I walk my dog down in this area occasionally. The dog is 8 years old, so for about 8 years I've been walking him down there. Having permission from my neighbor's property to walk the path that he normally kept cleared all the way down to the creek. I understood that the land was public, and I always cleaned up after the dog just as I would when walking the public bike trail or the Murraysville Park, respecting the land and our neighbors' efforts and the extensive time spent while performing maintenance and cleanup on the land. I would often observe wildlife and interesting animal tracks left in the mud near the creek, often unusable, way too wet, way too muddy, because the property floods numerous times during the year. Once the land has been flooded, it takes a long time to drain and dry. Anyway, Colleen and I have no opinion on the zoning. We only have concerns. my concerns about the shrinking wildlife area. We both would be concerned for someone who might want to build a home on this property and be unaware of the, and prone to regular flooding. You guys might have already touched on this, but it was something I wrote down, so I'll read it. I understand that the records have not been found to, that could explain how, why, or when this parcel became public land. I heard someone say they guessed that it might be an error in computer typo. And so with the lack of evidence, someone without knowledge, such as myself, I wonder how the process works, and I might speculate that because I don't know, that the land may have been intended as a donation, and the error was a failure to properly execute the donation process, or possibly it was properly processed, but the error is in some kind of loss of records. We do not wish to deny anyone's rights, and we have no issues with the owners of Murraysville Enterprise. I will have no objection to the land remaining public. And of course, we trust that the board will ensure that all rights are respected. Thank you.
Thank you, sir. Anyone else over there on this side? Anyone on the other side? No. Mike, let me just ask you, were you able to find the original subdivision plat?
Or this one?
Yeah.
Yeah, it is in the Dropbox. I did throw this.
It is in the Dropbox?
Yeah.
Yeah, I threw, oh, here's the floodplain map that you asked about.
Okay, so some of the property is outside the floodplain. Okay. And
What year is this map from?
Which one? Which one?
The flood map.
This is the most up-to-date FEMA flood map. I'm sure it's a couple years old. They don't update very often.
Original subdivision plan, Bob.
yeah, what, is there any special notation on there on this lot?
The only
It shouldn't be
special
further subdivided.
Cannot be further subdivided.
There's a 10-foot easement on there for the stream, outside the stream banks, it looks like. And that's all I see.
So Mike, from your digging around here, is I guess that land was all owned by Murraysville Enterprises or whatever they called themselves, and then they developed the piece of ground on the other side of the road.
Yeah, they developed, I think, 3 phases of Hills Church land that are kind of separated, and
Okay, and at that,
Fairfield plan.
at one of those, that Fairfield plan was developed, that's when the idea came about to do something with this parcel.
Yes.
Question.
From the Parks Commission meeting notes and the Planning Commission meeting notes, there was talk of maybe putting a baseball field there, but it says the residents were against it. I don't know which residents, if the ones in the homes next to this or the ones in the Fairfield plan. But it does say that it is intended, Lot 14, which is intended for a green area. So,
That's,
One more time, I'm having trouble hearing you.
sorry, which part did you lose me on?
Go back to, you made a comment about somebody objected to the baseball field, and then after that.
Oh, yeah, it just, in the Planning Commission notes, or meeting minutes, it does say that there was discussion of the Lot 14 property, which is this one, is intended to be a green space for the Fairfield plan of lots. But then it goes on to say that it has the covenants, which will not allow baseball fields, fences, buildings, or other changes, and the covenants are set to expire in the year 2000.
so the restriction, you could read this a couple different ways.
Yes.
Yeah.
And
Can you read the council note?
Yeah, council notes are, May 15th, 1989, this is where it was approved. There's a separate parcel consisting of approximately 3 acres, which will be green area according to Mr. Lynch. Sorry.
Yeah, speak up, please.
Okay. There is a separate parcel consisting of approximately 3 acres, which will be green area, according to Mr. Lynch, which is part of this plan. Mr. Lynch further stated that there is a covenant on that property that this is to be used for a single-family dwelling only until the year 2000.
That doesn't make any sense.
No, it does not.
Makes no sense.
Sounds like the intention is green space.
Yes,
The
absolutely.
entire time.
I mean,
Yeah, but it was never deeded to the municipality to preserve it as such. And I don't know what the heck that means about the covenant expires in 2000. That mean you can't build a single-family house on there until 2000, or?
No.
Or does
Yeah,
it,
there's-
is
I
it?
think it's the opposite.
well, I read some of the covenants talked about you couldn't build a ranch unless it was 1,900 square feet or larger. I think those are the kind of covenants that we're talking about, in my opinion. The fact that it was supposed to be green space for a rather large subdivision across the street, that kind of defeats the purpose of a green space. It's going to be a green space, it's going to stay a green space.
One would think, but nobody ever followed through with it. That's the problem. It should have been, if it was green space, it typically would have been donated to the municipality. There would have been a deed, and the municipality would own it.
Is there an HOA in the other subdivision plan?
I am not sure of that. I can say that we did find the deed for the stormwater pond for the Fairfield plan, but there's no mention of this Lot 14 when we accepted the stormwater pond.
Is
Is
there
the
any
stormwater pond on this property?
No, for the Fairfield plan?
Yeah.
I pulled that just in case they had kind of wrapped both of these parcels together, the stormwater and this Lot 14.
Has the municipality been maintaining this property?
No, we have not.
Who has been, do you know?
Unclear. Maybe neighbors.
Got it back there. Please give us your name and address, please. Use the microphone, please.
Or the people can't hear you at home.
Larry Armstrong, 3427 Hills Church Road. I'm also adjacent to that 51-foot right-of-way. I've lived there since 1990. It was not maintained by anybody, and I started maintaining it from then. Some of the neighbors can document that I've been there, neighbors that live there even longer than I have, that I've been maintaining it all the years, that property. And I can test the flooding is getting worse over the years. But yeah, no one's been maintaining it except I went down. There used to be the weeds and everything about over 6 foot high, and I started clearing it out and just mowing it, maintaining it every week for all those years since probably around 1991, and still continue to do that.
Thank you, sir. Mr. Attorney, you going to make a case for adverse possession?
I got to do the math. Have we put beyond 21 years?
All right, so I think we need to throw this back to the staff, dig some deeper, and see if we can get an opinion from the solicitor out of this, although I'm sure he'll be as confused as we are about what really happened back then.
One question I have is, okay, forget about the underlying use, what the intent was, whether it's supposed to be green space or whatever. Are we able just to designate something public land that's not owned by the municipality in this zoning?
No, not really. I would think so.
So, I mean, there is a possibility that this could be rezoned to the underlying zoning, what it was before, and it still couldn't be developed because it was intended to be open space or green space.
Well, this is it's a can of worms.
It sure
And
is.
I think we appreciate your input from the public on this, and we'll get back to you.
What about this adverse possession? I think that's a very viable.
Yeah, but it would be very expensive for the homeowners to approach it that way. Because they'd have to file a lawsuit, they'd have to give notice to everybody in the plan, get service. So if it can be handled administratively, it would be much
Better,
cheaper
sure.
and efficient. But no, I mean, I think the elements are possibly there, if you have to go that route.
Do they understand that? Can you explain that to them?
Yeah, if a property is owned by a different individual, but you, I'm just saying you, could be any of you, have been using it openly, notoriously. The property owner knows you've been there for an excess of 20 years. You can get or 21 years. You can get a court to order that you own it now by adverse possession. That's the easy version.
Simple version.
Yeah.
Simple version of it. Okay, well, in the interest of time here, can I have a motion that we close the public hearing and table this matter until the staff does more research?
Mr. Chairman, I make a motion that we table this at a later date when we have a little more information.
Second.
And close the public hearing.
Second.
All those in favor say aye.
Aye.
Opposed? Thank you. We'll try to keep you posted. Okay, the next item on the agenda is a public hearing for CU 425 DePietro conditional use. This is at 2575 Linda Drive. This is a conditional use application for animal husbandry, beekeeping on a 0.97 acres in an R2 medium density residential district.
This came before.
Is Mr. DePietro here? Sir. We see you've made a nice application for us.
Yeah.
Good evening. My name's Carl DiPietro, and I do reside at 2575 Linda Drive. And I did file an appeal to get a continuing use permit to keep my 2 or 3 beehives, which take up probably 30 square feet, not as big as the table there. What the zoning states is that in order to keep bees in Murraysville, you have to have 10 acres, and they classify bees as livestock. And I don't know when that was written. So there was an anonymous letter written to the code people, and they told me, I don't know if they should have, but it really was anonymous. They don't know who it was, or they don't know if it was a resident, a property owner. They don't know if they lived in Murraysville. They can't respond to it because of the anonymity. So they don't know if it was an 11th grader from Penn Hills or it was someone who lived here in Murraysville, because it was anonymous. They did have the facts right. You know, you need 10 acres, and you can't own livestock, which in my case would have been 2 or 3 beehives. So I came to the meeting, council meeting. I do remember Councilwoman Ling was there. I remember your name from the council meeting. And, a whole bunch of my neighbors, people that I see every day. I see them watering their lawn. I see them cutting their grass, tending to their gardens, sitting outside eating. My neighbors went on record, real people, to support my beekeeping. Of course, I give them honey from my bees. I don't sell the honey. It's just a hobby that I have. And I wanted the council to distinguish between a backyard beekeeper like myself and a commercial beekeeper who may need the 10 acres, who may have 70 hives. Okay, I have 2 or 3. One's weak. It'll probably die this winter. So the council suggested that I file this appeal, and I had to fill out some questions, and the counselor was advising me and said, here's what you got to do. You got to write answers to all these questions. So I did. I said, the bees don't, you guys should have a copy of it, of all the stuff that I wrote down. And I also gave all the neighbors who not only took the time to write their names and support me, but they also came up to the meeting and said, yeah, we support Carl in this. He's a good neighbor, and they're good neighbors. So I'm just here to answer any questions you may have about the 2 or 3 hives that I have. I think times are changing, and beekeeping is getting a little more popular. People understand the value of the bees. Every 3rd bite of food that you take comes from a bee. The bees are so unselfish, probably the most unselfish insect in that they provide something for man, honey. They also pollinate many of our foods. And they ask for nothing in return. So I'd like you to consider my appeal. I'm here to answer any questions that you might have, and thank you for the time to make my case.
Thank you, sir. Did anybody up here get a jar of honey? Not looking good, sir.
Well, I got a couple jars left.
I got a couple in the car.
Okay, so, Michael, there's some confusion in the ordinance.
Yes, another fun one for you guys. I'm sorry about that.
So what's this about the 10 acres?
Okay, so as Mr. DiPietro said, the ordinance does classify bees as livestock. You can raise livestock.
Sorry, that's wrong.
You can raise livestock by what we define as animal husbandry, which is a conditional use in the R2 district. The problem becomes that falls under agriculture, and when you actually read, it says in the RR and R1 districts. None of these things apply to the R2 district. So this is almost kind of another mistake, possibly, that we either missed adding the R2 district to the agricultural restrictions, or R2 was never supposed to be a conditional use. So we're kind of...
But the ordinance does allow animal husbandry as a conditional use in the R2 district.
It does. And none of the conditions such as storage of manure, needing 10 acres, needing
None of that
to be
applies.
200 feet, none of that applies to the R2 district. It's only to the RR and R1. I actually pulled the original ordinance, the text of it, to make sure there wasn't a mistake when it was uploaded to E-code. It says RR, R1.
Okay, so if we granted approval of this conditional use, we would be hanging our hats on the fact that R2 allows animal husbandry.
No restrictions.
Well, it's a conditional use.
As a conditional use.
It's a conditional use.
Yes.
And we would be forgetting about the clause that says you need 10 acres.
Correct. All we would really be held to is the general restrictions, or anything that you choose to impose or council chooses to impose as additional
So
conditions.
would this, so if we would recommend to council that Mr. DiPietro is allowed to keep his couple of bees there with conditions, would it not make sense to also recommend that the ordinance language be amended to include R2 in that district?
Yes, I think that would be a good recommendation to amend that.
Everybody
But
understand?
R2 doesn't have 10 acres.
Well,
I mean, you might have a 10-acre lot in R2, but the majority of R2
yeah,
lots
it's
in Murraysville are,
or not. Well,
Or not.
Well, they have to amend the language to allow beekeeping.
I was going to say, maybe amend the language to take out beekeeping from livestock.
Yes.
That's another way of doing
That's
it.
the part that makes no sense.
I have looked at multiple surrounding communities and how they treat this, and there's many ways that we could amend the ordinance to go about. It's just a matter of which direction to take.
Well, it seems like you're real easy to just cross out beekeeping under animal husbandry.
Yes.
There was a lot of discussion about this at the council meeting, actually, and President Dane Dice said that we would be looking at the verbiage of the ordinance at some point.
Okay.
What's going to happen, I don't know what the schedule is for that, but.
Mr. Wozniak, you had suggested a couple of conditions, and I can't find them right now. I think it's in the briefing.
Yeah, I can list those if you want.
That the, where, let's say location. blah, blah.
Tell you what, this is insane.
Staff recommends that no more than 3 hives on this property. Is that a problem, sir?
None.
Okay. And the beekeeping activities are for hobby purposes only?
Yes. Yeah, I don't, but once I let my grandkids sell the honey at a block party, but I don't sell it. I just give it to my neighbors. That's why they all came up and, supported me.
Well, why don't we just say it's not for commercial purposes?
Right.
Now, your beehives are in your backyard?
They were way back in the backyard, and then I moved them to the side of my house. And the property owner that's most adjacent to them is a good friend of mine. They don't impose any restrictions on traffic, pedestrian traffic.
You gave the neighbor a jar of honey, though.
Oh, a couple.
Okay.
I just want to say that I did provide council or the counselor with model language for municipalities for bee-friendly legislation in Pennsylvania. And, I said, maybe you guys can adopt this or amend it. But I believe, and I can't say for sure, that the city of Pittsburgh and Allegheny County have adopted that bee-friendly legislation. It's from the Penn State Apiary and all those good guys.
We have a bee box on the top of our Coppers building.
Yeah, there's bees at the Pittsburgh Airport, at the hotel there. It's kind of a growing thing.
It's a knock. I did some digging through the internet trying to find out, okay, what could go wrong here? And the only thing that I could come up with is sometimes bears and other animals try to get into your hive, and then people who are allergic to bee stings could suffer an allergic reaction. But that doesn't, I don't think because you have a beehive there, they could get stung walking down the street too,
Yeah, the bees, pretty much, as long as you don't try to distort the hive or
Disturb them,
attack
yeah.
the hive, disturb the hive, or disturb the bee in themselves. Bees, they just want to be left alone to do what they do for us. Give us the good jar of honey and pollinate our fruits and vegetables and nuts.
Okay, so I guess what I would ask the planning commission, if you're ready to make a motion recommending this conditional use to council with a change in the ordinance language to accompany that, eliminating beekeeping from animal husbandry. We think that's the best way. And with the conditions that there be no more than 3 hives on the property, and that's for, and then are not for commercial purposes. How about, do you have any problem with we add, no, the hives will not be in the front yard?
Yeah, they shouldn't be, in sight,
Okay.
somewhere on your acre.
All right. Can I have a motion to that?
Chairman, I make a motion on CU 425, the peach tree conditional use, that we forward this on to council with our recommendation for approval, stating all the conditions that you just stated.
Okay.
Second.
Second. All those in favor say aye. Aye. Can we have a motion to close the public hearing on this matter?
So moved.
Second.
All those in favor say aye. Aye. Okay. Good luck, sir.
Thank you. I want to thank the Planning Commission.
Somebody else did say it too.
Okay, we're going to change the agenda a little bit. So we're going to go to number 2 here. There's a discussion recommendation for S225, the Summer Hill Phase 2 subdivision. This is on Goldie Lane, really off of Logan's Ferry Road, to subdivide 122.8 acres into 64 lots, of which 61 are townhouse lots, 2 are open space parcels, and 1 is a private road parcel. This is in an R3 zone district.
I'm sorry. You want the plans up there?
Yeah, we can. Thank you. Good evening. Jeff Parabeck with Ascent Consulting and Engineering, representing Summerhill Development. We've spoken about Summerhill quite a bit over the last year or so between the conditional use permit, construction documents that we've submitted, and had recommendation for approval with conditions for the construction documents that are working through some of the conditions on that. This is the final subdivision plan for the development to create the lots that we had laid out with the construction documents. A couple of the things that we've incorporated, you had requested during construction document stage that we subdivide a parcel out to convey to the condo owners association if they decide that they want to take it to correct an earlier existing issue with the yard setbacks not necessarily meeting the minimums that were on the original subdivision plan. We've also, so far as sanitary sewer outfall, which is down North Duane Drive, we have gotten comments back from Plum Municipal Authority that we've addressed, and we haven't gone back yet because we also just got comments from FTMSA that we're in the process of addressing. All those are rather minor. So far as the easements and permission from the landowners on North Duane Drive for the sanitary sewer and the connections from the grinder pumps, Mr. Hall has been negotiating the easements and easement agreements with the few homeowners where we actually have sanitary sewer that the easement would be within their properties. We're currently, for the construction documents, under review by DEP and the Conservation District for the NPDES permit. DEP has decided to do a concurrent review with Conservation District, which is something new. So I'll answer any questions you may have regarding the subdivision plan itself.
As I recall, there were a number of conditions attached to our previous approval.
The construction documents, that's correct.
Yeah, it was sewer planning modules, approval from the North Duane people, getting your NPDES permit.
Right.
Anything else, Mike?
Nothing else I can think of.
Was that application, was the land development plan application submitted at the same time as the conditional use?
No.
No, the conditional use, well, we started out with the land development application and then realized that we needed a conditional use due
Right.
to the amount of grading. So we halted that, applied for the conditional use permit, which was recommended for approval. And then once the conditional use permit was recommended for approval, then we submitted the land development application. And then finally, this is the subdivision, follow-on subdivision plan.
Did we actually, did the land development plan
Yeah.
come through here?
Yeah.
Or, okay, that was on the
Yeah.
same, that was the same meeting? Okay,
Yeah.
okay, that's what
That was a separate meeting from the conditional use, but yeah, it
Okay.
was recommended for approval with conditions being, as Mr. Meidel said, the NPDES permit, the North Duane Drive coordination.
Where is that NPDES review with the Conservation District?
We have been accepted for review, technical review for the Conservation District. We went through the process where it used to be just administrative, now it's more of a technical review.
Yep.
And it was submitted to them, and then as I stated, DEP has started wanting to do a concurrent review along with the Conservation Districts, which is something new that, used to be just the Conservation District unless you're in an individual permit. And so now both of them are reviewing that concurrently.
So have you got official technical review? I understand it is that with that administrative review, you get some technical
You
comments.
get a lot, actually, it's more technical review than it
Yeah,
used
I
to be
understand.
for.
But have you got the official first technical review comments back?
No, we have not.
You have not, okay.
Conservation, from the time we submitted it, they had it approximately 60 days before they accepted it, along with DEP, and I'm not sure if that has something to do with that or not. I'm kind of new to the way they're doing that now.
Yeah, it's not getting any easier.
No. Okay, if we made a motion to, well, first of all, let me ask, anybody have any questions on this?
No.
Oh, and I'll also add that we did receive comments from staff earlier, that we coordinated with them and made revisions to the plan. Also, at the request of staff, had reviewed by county planning as well, which is somewhat unusual, but we went ahead and did that. And that's where the briefing that you have there, we've addressed all of their comments.
Looks like everything's been adequately addressed.
That's correct.
So the conditions would be, we have to get an NPDES permit. We have to get the approval from the Duane Drive folks, and we need FTMSA and Plum Borough
That's correct.
approval of the construction plans, and has anybody signed off on the sewer planning module?
Planning module has not, and I've got to follow up with where.
So we
that
need
is.
planning modules. Anything else? No? All right. Boys and girls, what do you want to do? Yes, ma'am. Give us your name and address, please.
I'm Vivian Hunter. I live at 3838 Goldie Lane in Summerhill, and I just needed to understand, we've been working with Gary and our attorney to get the amendments because we had the issue with the property line, if you remember correctly, the 50-foot offset of the property line that needed to be addressed, as well as there's going to be a withdrawal and an addition of property that has to be amended to the summer, and it was not noted, by the way, none of that was noted as a condition on the minutes from last month. So I just wanted to make sure, is that a conditional, because we're working on it, our intent isn't to be combative or anything. We have it's very, and I think Mr. Lemke will agree, I think you did a lot of the stuff in the beginning. It's just really a quagmire of stuff, the way the property lines were made, and now we have to change them.
Thank you for bringing that to our attention.
If I can address that real quick, there were amendments adding real estate throughout the project, but the initial plans would have had the outline of the whole plan. So the setback issue is easily seen on there. And as far as those amendments are concerned, if you guys hired an attorney, those are public record, they're easy to get.
Yes, and we've been working with that. I think Gary and his engineer will attest to that, because I think the biggest issue, too, was with the property lines not be correct. You know, we have had some sale of property up there, and the title search has been, is okay, but there is an intent. I mean, there's a possibility that if someone sells something and does a title search, it's not going to match up with the way the original plat was in the original subdivision. So it was my understanding that this was one of the conditional uses. Not that, once again, not trying to be combative or to stop anything. We need to understand if a declaration needs to be made to our bylaws, which is a different process, or if it can simply be a corrective amendment, which is a much easier process to go through from an HOA board perspective, as you understand.
Yeah, I mean, I don't know who represents you guys, but if that issue needs to be fixed, which I haven't looked at it can be done by an amendment of your declaration, or it can be done by an easement given from Summerhill Development back to you guys.
Right, and we're working on that. But I just number one, make sure, as I went through the minutes and reviewed the transcript, well, I transcribed it, I used to do that, there was nothing in there about this being an issue or something that needed addressed.
You're absolutely correct. It was discussed here several times. And Mr. Engineer, I know you
Okay,
have an
thank you.
answer to this.
I'll wait for the comment now.
Yes. If Mike could pull the subdivision plan back up very quickly, please.
Subdivision current.
Okay, it's kind of small up there, but you can see the long sliver of a parcel at the rear of the condo buildings themselves. That parcel was created, that's called lot number 22. That parcel was created to create the 50-foot setback from those buildings to where the new property line would be. And essentially, that could be conveyed to the Condo Owners Association should they decide to accept it. That starts to get into the transfer and the negotiation between them as to what the proper vehicle is for that. However, we've created that parcel for transfer so that it could be transferred.
Okay, so does it say anywhere on there that that parcel is to be conveyed to the, what is it, the Summerhill Phase 1 HOA?
I believe that there's a note to that effect.
It's back. I need to look at it. Yeah. We're talking about this right here.
And I have to apologize for not knowing exactly where all the notes are.
I understand. Let's see.
Okay.
Is there an existing building on Lot 22?
No, there's nothing
So
on that.
that's labeled building there, that's,
Oh, that one down there, that is an existing one that somewhere from going through the legal descriptions for the different withdrawn lands, I don't know how that happened, so we're correcting that as well.
what do you mean? There is a building there or is not a building there?
There's an existing building there.
There is an existing building?
Correct.
Okay. What is in that building? Is that,
That's a duplex.
okay,
Something through, all the amendments were done by legal description without any real plats to go with them. And so I think there may have been an error with that at one point. I can't speak to that because that was before we were involved.
So you need a lot line somewhere to distinguish the building lot from 22.
No.
no, that whole
because they're-
sliver
they're-
back there is going to
The
become
sliver
part of
is-
that.
There are no lot lines in that
Yeah.
plan.
It being a condo, the property is owned by the condo association, the individual buildings are owned by the condo owners.
Understood. Gotcha.
I think the only thing, I don't see it here in the notes sections here about that.
I'm not immediately finding it, but that's something that we can definitely
Are you calling
easily
that
add.
lot 22 or lot 20?
22.
22.
Okay.
Hey, guys, I'm
Mr.
Gary Hall with the developer. Just so you understand where this is at, we've been working with Bill Abovitz, which is their attorney. The big thing in question, and Joanne can verify this, is exactly, everybody agrees upon what's trying to be done here, is exactly how it has to be done, either by amendment, okay, or do they have to get a vote of the entire development, or can it be corrective? The comment about an easement's kind of interesting. I mean, this is something that I can work with Bill and get Ryan involved to some extent to work out whatever article we need to use or however we need to use it to simplify how it happens. But I think in theory, and Joanne I think she'll verify that, this is the intent of what's to be done.
Okay, and that moves, oh, it disappeared, but it moves the property line more than 50 feet away from the existing buildings.
Correct.
Okay, so we just have to make sure that that's
Notes on the plan.
noted on the plan or however. Follow it up with a deed or whatever, however you do it, an amendment.
Yeah, and we can make a note on the plan, the intent for that, and then whatever the appropriate legal mechanism is for that to happen.
And the staff just has to make sure that that happens.
It's kind of funny to have, isn't it?
No offense, Mike, you weren't here back then. Okay. Does that take care of it? Does that
It's
answer your
Joanne
question?
again. Yeah, it does take care of it. I just want to make sure it's noted on the minutes here, and it's noted, I need clarification. Is it a conditional use? Because to Gary's point, we have we're trying to make it simple, trust me, but it's like peeling back an onion on how all of this documentation was done over the years. And,
Well, I'm going to make a motion, and my motion's going to include that this has to be noted on the plan.
right, exactly. And because I think even at the last meeting, I think Councilman Ling was saying that, you know, all conditions have to be met before development to proceed. So we're working as fast as we can. And as Gary said, it'll be easier to do a corrective amendment, which can be approved by majority of the board. But if it's a change to the declaration, then that means that we have to get, I think, almost a 90% vote of the residents. So that's where that's the issues lie. So we're in sync, and so I just wanted to make sure that you
just
understand
wanna make
that. And
that-
it's noted, because as I said, it wasn't noted last month, so. Okay, thank you.
Thank you. Okay, so we have an NPDS permit, agreement with the Dwayne Drive people, FTMSA and Plum Borough approval, planning modules, and
We need the note on the plan for lot 22.
Is that a motion, Jane?
That is a motion. I
Do- do-
recommend that we move this forward to council.
The
for
second
approval.
by
Second.
Chris. Thank you. All those in favor of the motion say aye. Aye. Those opposed?
I abstain.
Abstentions because you represent the applicant.
Yes.
Okay. Good luck, guys.
Thank you.
Okay, this number 3 here, discussion and recommendation for Z225. I think we already covered that, did we? Did we not?
We did number 4, too.
We did number 4 as well. Okay.
We're left with number 1.
We're left with number 1. Mr. Kearns, are you representing the applicant?
Yes, I'm going to recuse myself because this is my property, and I will actually present it for you as well. My company did the work. Good evening.
Good evening. Your name?
Chris Kearns with Eco Land Solutions. So it's a simple subdivision, 6 acres. I have the property. My mom lives on the house in 3748 Windover Road. It's 9.6 acres currently. I'm just subdividing this 6-acre parcel off, which is going to have access to Hay Lane through an existing right-of-way that was created by deed back in the 70s. So it's a pretty simple thing. I think the planning module is already signed off on by FTMSA. It has access to sanitary sewer from an existing sewer main through an easement. So the planning module's here, ready for signatures after it goes through the process. Got a clean bill of health from the review from the engineers, and all outstanding comments have been addressed to this point. So, if you guys have any questions, I'd be glad to answer them.
I do not.
Members of the Planning Commission, anybody have any questions for the applicant? No?
There's somebody that wants to speak, I think.
Pardon me?
Somebody that wants to speak.
Oh. Sir, please give us your name and address, sir.
Yes, sir. My name is Bob Shepard. I live down on 4832 Treesdale Court. The reason I'm here is because of the new business that was just discussed just now. There's a civil lawsuit out there on this Murray Crest plan.
What? I'm sorry, say that again,
Yeah,
sir.
I didn't
There's-
understand what you just said.
This Murray Crest plan, what Mr. Kearns is referring to,
Yes?
there's a civil lawsuit out on this tract of land, on this Murray Crest plan. And it's public knowledge. I have the case number here. If you folks want to look into it, or you look it up yourself.
What?
What's the basis of
Yeah,
the suit?
please.
Can you explain what's going on?
I don't know what you're talking about, so if you'd explain it to me, I'd appreciate that.
Well, we live down below.
I understand. I know Murraysville very well.
Okay, well, there's been a lot of difficulties here, and there's been a lot of things surrounding.
Like, for example.
Well, I'm not going to get into all that right now. But I just want to tell you that we're opposed to what he's trying to do as far as this property goes. Until the situation is straightened up, it was down there from before. I got big problems down at my house, and I say it involves all of that. So that's
Can I
where I'm
ask how long you've had these problems?
Well, probably about 4 or 5 years now that can't seem to get addressed. 6 years.
What kind of problems?
Well,
Wait,
sorry.
one at a time. You're welcome to speak.
is it okay for her to approach?
Sure, sure.
If she wants to speak, that's fine. Just,
She'll pick better.
Please use the microphone, please.
yeah.
I'm Gwen Shepherd, his wife, live at 4832 Treesdale Court.
Okay.
I have lived there over 25 years,
Okay.
okay? What Mr. Kearns is proposing now is property within the Murray Crest plan. Okay?
Okay.
The Murray Crest plan, right now, there's a civil lawsuit that involves that property. We can't discuss it here, but you can look it up. It is public knowledge. It's out there. It is filed in Westmoreland County. It's case number 22CI0559.
Say it again.
Case number 22C as in cat, I0559.
22 CI 0559.
Correct.
Okay, very good.
Are those ones, ma'am? Because I don't think Westmoreland County has, after the CI, I think the
Be a
rest.
one.
Yeah, the rest.
It's a straight up and down line.
So can you give that to me again then, please?
Okay. I'm going to call it I, but it may be one, okay?
Okay.
22CI0559.
So it's probably a 1.
The last four you said were 0559?
Correct.
Okay, thank you.
Okay? Now, will what's being proposed here be available for public viewing, other than what was thrown up there? 'Cause
Yes,
you really
ma'am.
couldn't read it?
You can come down and see Mr. Wozniak there, and
Okay.
he's
You
here most
in the
days.
building?
Yes.
Okay, thank
You
you.
certainly can, you're welcome to come down and see any of it, any time, any of that stuff at any
This is
time.
broadcast on the local station, and this will be repeated again. I don't know what the date is that they repeat it, but, you know, this is all public record, and you're certainly welcome here anytime.
Just need to be aware of this. Thank you.
Okay. And you said,
I do have one more question.
yes, sir.
Bob, you and I spoke about this matter that I was having before.
Yes. And I did go up to your
Told
place.
me that you would get back to me. You never did.
No, I got up to your place and I believe Mr. Ramali was over there digging and
Yeah, Bill was doing that.
doing a lot of work. And I'm sorry, I'm a little bit incapacitated. I have difficulty
understand.
walking.
I understand.
But I was there and looked at your place.
But you claimed that you were going to get back in touch with me. You never did.
Sorry, I did not. No, I was in the
So
hospital.
I'd still like that meeting.
Okay, fine. Mr. Shepherd, after the meeting, would you please give me your phone number, please?
Sure.
Okay.
You want it right now?
No, after me. Okay, boys and girls, what do you want to do here?
Could I make a comment first,
Yes.
Mr. Chairman? The fact of the matter is, that regardless of the civil case, this is not a legal body. This property is not encumbered. I do not have any legal restrictions on this property. The case before you is for a simple subdivision. Recommend approval. That's it, and it meets all the conditions, and it's met all the conditions with staff, so.
No, and I think it's important to note too, for these folks, even if this subdivision goes through, if you go to sell either one of these properties and there's a judgment entered before that sale, it's going to have to be addressed. So just doing the subdivision doesn't, in my opinion, affect whatever lawsuit is out there.
Does everybody understand what
Yes.
Mr. Lemke said? Okay. Okay, you have a legal opinion, you've heard from the residents who object. What do you wish to do here?
I'll make a motion to recommend for approval S-9-25 Hay Minor subdivision. And I don't believe there's any conditions that we discussed.
Mr. Wozniak, there are no conditions with this.
No, no conditions.
Is there a second? Second?
I second.
Second, moved and second. All those in favor say aye. Aye. Opposed? Abstentions?
Abstain.
Mr. Kearns abstains. Okay. Thank you. Okay. Well, we're whittling this down here. Next is a discussion recommendation for SP 225 Communications Tower. This is at 4900 Lasher Court. It's a preliminary and final land development application for a communications tower. And I believe gentleman has been here before us, and we told him that he had to go and get a do a land development process, which he has done. And I believe, no, wait a minute, it's Pete. I'm sorry, got the wrong numbers here. Okay. I believe that they've addressed everything. Is that correct, Mr. Wozniak?
Correct. There are no outstanding comments, and they did submit the waiver request. That was the discussion last time.
That was mainly the only thing I believe we were.
The waiver had to do with landscaping.
No, the waiver was for the several different environmental impact
Oh,
studies.
yeah, whether it's made a noise or traffic study and all that.
Yes.
Do you have your NPDS permit?
No, sir. Because we're under 1 acre of disturbance, we're exempt from the NPDS process. But we did obtain Westmoreland County Conservation District approval on 2 levels, erosion and sediment and stormwater management, both approved from Westmoreland County Conservation District.
No other issues, Mr. Wozniak?
No issues. Everything's buttoned up with this one.
Planning Commission members, any comments or questions?
No, Mr. Chairman, I recommend SP 225. We forward this on to council with our approval for the communications tower 4900 Lasher Court.
Second.
Second, all those in favor say aye. Aye.
Thank you all. Have a good evening.
Thank you. Okay, discussion and recommendation for Z125, the Reagan Ridge rezoning. This is a rezoning of a 0.826 acres of land it's at the intersection of Wilson Road and Manor Road. Mr. Gusty.
Good evening. My name's Ray Gusty from Farragut McCarty Gray. So based on last month's meeting, at the suggestion of Planning Commission, rather than ask for rezoning of the entire parcel A, which is an area outlined in the heavier dashed line, we're asking for rezoning of just the area outlined in blue near the intersections of Manor Road and Wilson Road.
So that would require subdivision?
I don't think it has to be a subdivision. I think you can have a property with zoned to different zoning districts.
Yeah, we have multiple split zone parcels.
How big was the big piece, Ray?
It was like 3.1 acres, I think.
Okay, and so
We reduced it down to like
you're less than a third of it.
0.8 acres. So that crosshatch area meets the minimum requirements of a parcel in the B zoning district.
Okay, and we talked about getting an entrance in there. I mean, did you look at that as far as you're able to get the entrance back far enough from Manor Road?
Yes.
Right, okay.
Okay.
All right, very well. I think that took care of my concern, getting it away from the residential units.
Can't do anything anyway with all the easements, but I mean, I think it was a comfort level for some people to reduce that, so.
Any members of the audience have any comments on this matter? Sir? Yes, sir. Come forward and give us your name and address, please.
My name is Bill Mura. My wife Janice is here with me also. We live at 2330 Wheatland Circle in Westmoreland Farms, and that's adjacent to the Reagan Ridge development. What the gentleman just said addresses some of the concerns we have, but I'm going to go ahead. There are still some things that I think ought to be brought up and talked about. We've resided there since 2011 and overall have been Murraysville residents for 30 years. Our comments are based on information presented at the July 8th Planning Commission meeting, which I attended. It's been over 3 years since work began on what used to be a scenic working farm field that adjoined our backyard. We now look out on 2 unfinished buildings and 1 foundation and other excavated areas with no end in sight on the construction. We're concerned that the developer appears to be in no hurry to complete the project and seems content to see the site remain in the unfinished state indefinitely. We expected that there would be development someday on the property behind our house, but we figured the work would be done on a reasonable schedule. The project timeline on the Fusting website shows the work to be years behind schedule. Marketability of the units is also a concern. Locating these high-priced condos near power lines, gas lines, retail businesses, and a 4-lane highway represents obvious obstacles to marketing the units, a situation that's widely discussed in the community and on social media. Further, it was stated in July that the barn at the intersection of Manor and Wilson Roads would be replaced by a gym for use by Fusting employees, with the possibility of additional commercial development on the property. The original plan for this parcel, which is still on Fusting's website, shows the barn as an activity center for the Reagan Ridge community. We would like to see the original plans carried out in order to attract buyers. We feel that approving zoning for unspecified future commercial uses would put off potential buyers and further delay completion of the Reagan Ridge units, and will also affect property values in Westmoreland Farms. We urge the Commission to reject the proposed zoning change and not consider any additional business zoning until the planned residential units are completed and occupied. Until then, any commercial development should be done in the area across Wilson Road, which is intended for business use. We think it's in the interest of Murraysville residents to have the Reagan Ridge development completed without further delay. We ask the Commission to take any steps that it can to ensure the developer completes Reagan Ridge construction expeditiously and does not leave an unfinished and highly visible construction site indefinitely. Thank you. I have a written copy of this if you'd like me to leave it.
If you would, please.
Okay. So,
Give it to Mr. Wozniak. Does anyone else have any comments on this matter? Name and address, please.
My name's Diane Doherty. I also live in Westmoreland Farms, 2372 Wheatland Circle. Mr. Mura made valid points that many of our neighbors have talked about for these last 3 years. We look out on an unfinished condo unit, a partially one that's just been started, and this has been going on for 3.5 years. Many other housing plans have been started and completed within 3 years, and we just don't know why this is taking so long, and we're just looking out on raw dirt most of the time. In addition to the condos having a completion date on the original plan of 2023, the Phase 2 of the Fusting Executive Park Plan, the DNA corporate office was to have a start date in 2022 and a complete date in 2025. Phase 3 was to begin in 2025. None of these dates have been met. We are questioning the track record of the past proposed projects and are concerned about starting a new project in the midst of all of this unfinished business. The Murraysville Subdivision and Land Development Ordinance 706-05 requires the execution of a developer's agreement, which includes, among other things, a timeline of construction. Before any further rezoning or new construction is approved, I would ask this Planning Commission to revisit the original agreement for this condo development and the Fusting Executive Park. Thank you.
Anyone else on this matter? No?
Mr. Wozniak, do you know, it was referred to something, maybe it's just marketing material, that area up front was referred to as an activity center or zone. Was that something that was part of the original plans?
So I dug back through the meeting minutes. Obviously, I was not here for any of that, but the barn is discussed at length. Where it kind of left off is that the barn was to be separated out from the home part of the plan, not to even be talked about. It's not part of it.
Okay, so
so it is on the plans if you actually look at them, but they are not. It's not on the plan.
Okay,
It's just
so-
there for reference.
So whatever this activity zone is marketing stuff that's out there.
Yeah, I don't
Nothing
believe
to do with
there's,
the plan.
I don't believe
recording
there's anything in the developer's agreement that it is to remain or anything like that, so.
Okay, thank you.
Sir, go ahead. Come forward, please, and use the microphone.
Just to clarify, what I was referring to is the plan that shows the whole Phase 1, Phase 2, the lots and the corner where the barn is, and there are notes on there about it being an activity center. So that's
Where did you see this plan, sir?
It's on the Fusting website.
Yeah, I can pull it up for you right here. This is part of the plan set.
Well, I do recall having some discussion.
So that's where that came from.
With that was supposed to be an activity center for the plan, but I don't think it was ever monumented as such.
Yeah, I don't know, Mr. Gusty, if you want to speak to that, if you remember.
Wait, go back where you just were.
Sorry, it's scrolling on its own.
It was part of the original plan. I mean, it's separated from the condos. And I just want to note that Mr. Fusting did pay into the recreation fund, so this was like extra beyond that. He did pay into the fund for the recreation fees.
Do you have access to the 2022 planning folder? August 22?
I don't have that on, or the Dropbox, I might.
So I pulled up M1 Master Development Plan from August of 22. That park section, Phase 3, we've got existing barn, convert to activity center.
Oh, it's right on the plan.
Farm-themed playground, lawn area, walking trail, meadow grasses, parking, stormwater management.
What date was that?
August 2022.
23rd or 9th, do you know?
It's on M1, drawing M1.
The 23rd.
Okay.
We can't see that, Tony.
Where did you find that?
Planning folder. Old one, long time ago.
Oh, okay.
So go to,
Is that under planning 1?
so hit planning.
Planning?
You don't see it in that one.
Is this the one?
Mine's slightly colored, but yeah, I think it's very similar.
Look at the bottom right and see what drawing number that is. Keep going. Okay. That's what he has, M1, but I don't know if the dates are the same.
Well, is that drawing there, does that?
2022.
June 15th, 2022. What's your drawing date?
August 23rd.
August 23rd.
Oh, sorry, that's the actual date in the planning folder. Let me pull up the document again. June 13th.
Yeah.
6/13,
Yep.
2022. Okay, so it's the same drawing, the one he's looking at, just in color. So it is noted on the plan that that's supposed to be a activity center.
It also has all those bioretentions on there. Not all those were constructed, were they?
Yeah.
There's detention basin and.
But the fine.
That's an older version there. There's a detention basin and there's a 4-bay. The two W's were in.
Okay, right. But that one, well, the one on the bottom is labeled W, but it's not in. That's not built, correct?
That one's in.
At the corner?
The bottom
Yeah, it
right.
shows on the
Bottom right-hand
recent
corner, yes,
plan.
that's in. The right, the bottom right-hand corner, that detention basin is in. Two W's are in.
So it seems that the original intent was that this was an activity center for the benefit of the people living in the condo association.
I believe so, yes.
Okay.
But if there's no people living in the condos, then
Well,
Well, that doesn't change the intent though. Somebody's gonna live in them someday.
Can they use the gym?
then maybe that's when you do the activity center.
Well,
What, is it gym and activity
Uh,
center?
Yeah, they would be able, I would think they
yeah, I don't
would
want to
be able to use the gym.
Free membership lifetime when they
No,
purchase a
they
condo.
zone it B, they can make it anything
throw
they
some-
want.
Some free weights
Doesn't matter what
in
they
the
say.
shed and call it a gym.
So then why would we do that? So I would not support rezoning that.
anyone else care to chime in?
I agree. If you tell us it's gonna be an activity center for the residents,
Then-
it's on paper and on the plan. My other question is, I've had several building permits in Murraysville, and I think they're only good for a year. How long are these building permits good for?
Well, that's different from the land development plan.
Yeah.
Is that what
Yeah.
you mean, like to develop the property
Right.
for these units?
Yeah.
Yeah, the individual permits would only go in when you decided to build the building.
Yeah, and as long as there is work being done, it's kind of hard to say.
That's a flaw in our ordinance.
Yeah.
in
I
that
believe
there's
that's
no-
the
Other
ICC's
ordinance we
flaw.
need to fix.
Fixed, yes. Okay, so someone would care to make a motion and recommendation to,
Chairman, I make a motion that we deny this request for rezoning.
A second.
is there a second? All those in favor of the motion to recommend denial, say aye.
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 Opposed? Abstentions? Sorry.
Sorry.
Let's see, the last one here is, I think that's the end of it, is discussion recommendation for CU 325, SP 325, and S 325. This is Drake's Car Wash, a lot consolidation, and preliminary and final major land development application. This is for a 1.16 acre, 2 parcels. It's Zone B. This is at the site of the former Choice Auto Sales on, between New and Old 22, next to the, what used to be the PNC Bank. It's now the church owns it. This would be towards,
School Road and 22.
towards, away from School Road, towards the Get-Go place. Okay?
Yeah.
Yeah.
We got it.
Okay. Mr. Wozniak, are there any outstanding issues on this?
There are some outstanding third-party issues, NPDS permit, that kind of things. There was a comment about the vehicle routing, but they did provide an updated version of that. We did also receive the acoustic review yesterday and the traffic review today. They are both clear. I know there was some issues with Tommy's with the acoustic analysis, but the ordinance actually changed in between. So it's a little more forgiving. They do meet all the requirements. I think the recommendation is that post-development, there be an analysis on the west side, over on the old PNC side, just to make sure everything's good there and doesn't need any further mitigation.
Could you say that again, sir?
The acoustic analysis, sorry.
Yes.
Yeah, so the ordinance changed, I want to say in 2020, sometime after, after Tommy's came through. And we had the same acoustic analysis company run the numbers. It's more forgiving. They meet all the requirements currently, and their only recommendation is post-development to do an analysis on the western side over on the PNC side, just to make sure there's no future mitigation needed there.
You're aware of this? Mm-hmm. Okay. And the outside third-party ones you're talking about is PennDOT and...
Yep. PennDOT, FTMSA, NPDS, the usual ones that are outstanding. Yep.
you have any, anyone have any questions on this?
What about the cover for the vacuums?
No, that's what Mr. Wozniak was just referring to on the
I didn't understand that.
acoustic. Apparently, the ordinance was changed, and
Any outside
mechanical devices.
mechanical devices have to be covered. You're saying that was changed?
No, I think what I'm referring to is, it is enclosed, is it not?
The vacuum equipment is enclosed, yes.
Yes, but the
No, wait.
the end of the vacuum is not enclosed. It's one vacuum that works all the, how many of them are there?
There's 9, 10.
9 stations.
I think the difference was Tommy's had, I want to say 15, and they each had their own motor. Whereas this, please correct me if I'm wrong, you have one motor that powers all of them.
Yes, a compressor.
Yeah, one compressor.
That's amazing.
You should know.
Yeah, I mean,
What?
So,
How?
if this thing's running and it's capable of doing 9 stations, or how many stations?
9.
9 stations, and you're using one station or all the stations, the noise level is always going to be the same or higher. I mean, I just,
But that's why it's enclosed, is it not?
It is correct, yes, it's enclosed.
so what do you hear at the end that's out there, this sucking sound, I guess?
Just that.
Yeah. Just that. That's the noise that you hear, yes. And again, as Mr. Wozniak stated, it's all in line with the municipal ordinances.
And that vacuum, those vacuums are always on.
The compressor, can
If I pull up to that station number 7, and I get my hand on that vacuum, it's running.
You gonna hit a button or something, or?
No,
No.
they run. As soon
No,
as you
no,
pull
no.
them out.
No, yeah, but you know what, that doesn't make sense. If the whole place is empty, these things aren't running, right?
The compressor is on and then it throttles. Like the energy is able to.
Yeah, I understand that, but I'm saying if nobody's there, if all the stations are empty, you mean this thing's running? It's not on demand?
There's not a button you press to turn the compressor on. No.
Okay, so there's nothing that you, like a gas pump, you pick up the handle, it activates the pump. So you're saying when this thing picks up, so this thing's running 24/7?
During operating hours, I would imagine.
During operating hours, and if
It's on.
If it's a rain day, then the employees can turn it off. And there's different technology that's been installed to decrease the energy requirement to support it, but yes, it is on.
And we don't
Something doesn't
require that
compute.
to be covered.
Does it work kind of like a compressor for, say, a power washer, where it pressurizes it up to a point where you can use it, and then when it drops below a certain level, then it has to turn back on to repressurize?
I can't speak to
So there's no, I guess what I'm asking is, there's no downtime to the noise. Is that what you're kind of getting at?
I guess there's something missing here in your story. If the thing is on and Jane pulls in, she's one car, so the thing's running. Now, if all of us show up at once, how does it know to increase its speed or whatever to accommodate all of us using the vacuum?
Well, so the compressor is in an enclosed area, and that's.
We understand that.
They're all ready to go all the
What-
time.
So it's, the hoses are sucking continuously, is this what we're saying?
Yeah, it's just something.
Wait a minute, guys. This can't be, you can't be serious. Listen,
Not always.
I don't know anything about your plan, but the only thing that makes sense to me is that this is an on-demand unit. So the unit is available to provide vacuum when one person pulls up, and if a second person pulls up, you're describing a control that increases its capability. Maybe, I'm not sure what type of compressor it is. I'm trying to figure out how you get variable capacity. But that would make way more sense. But I cannot imagine that this thing would be running when nobody's there. I mean, if you're open 8 to 5, I cannot imagine that this thing's running when there's nobody at any of the stations.
Yeah, what turns this thing on? I mean, if I pull up, there's this hose hanging there, and I want to vacuum out my car. Don't I have to push a button or something, or?
No, it's, you pull it out and then you can vacuum.
Yeah, but if you pull it out, my belief is there's got to be a switch or some kind of a contact that senses that this thing's been pulled out and is being asked to function.
That could be possible, honestly, I can't speak to
Okay, so
the technical nature of that.
So that's probably the case.
Yeah, huh?
That's probably the case.
Yeah, I mean, trust me.
I would agree that it's probably
Yeah.
off when it's in and on when it's out.
It's not just running,
I was
you
gonna
know,
say, you go back
sucking
and
up
you
the
shoot
dust.
your engineer. If that's not the way.
Not
it
this
works,
one,
you go
yeah.
back.
Not the site engineer.
We got too many engineers around.
Okay, so they've submitted some sort of an acoustical study, and there would be after this thing's up and running, they've got to do another study to check the noise levels on the PNC side. What about the poor people on the other side of the street that are going to have to listen to this thing that does or does not ever shut off?
But you know what? See, that doesn't make any sense. If you have an acoustic signature based on whoever's providing this device has to know the acoustic level this thing's producing. So that either falls within the ordinance or it does not.
Yeah, and that information was all provided as
Yeah.
part of the study. One of the items that was implemented to address the residents, properties on the north side, was the recommendation for a sound wall to be installed, and that is installed at the parking lot level behind the vacuums. So it's a 6 or an 8 foot tall wall. So basically, it's a fiberglass, or not a fiberglass, but a particle board wall with sound deafening material inside the structure itself. So that's installed on the northern side at the parking lot level behind the
The individual
Okay, so that's
stations.
That is correct.
So I guess the question is what about the other directions?
So that's part of the sound study that was approved with the only mitigation measure to have the post-study done completed on the western property line.
Yeah, and I think part of that is the, when you exit, there's the dryer when you come out of the car wash. I think it was to analyze that.
That is correct, yes. Yeah, all other areas on the property met the municipal requirements.
Okay, so I recall some discussion on some glazing, maybe in the building too. That all was addressed?
Yep, that was all provided, so I don't know if you had a chance to review that or not, but the, all 4 building elevations were revised and updated.
Okay.
Essentially, I think we're at 18, 19, 23, and maybe 21 or something like that percentage. But if you don't have that, I do have a copy of it, or Mike, if you could pull that up as well.
Give me 1 second to see if it's in this folder.
I think those were the 2 things we were kind of hung up on at the last meeting.
That is correct.
Wasn't the queuing, wasn't that traffic thing also?
What, yeah,
We addressed that one.
That too, yeah.
You have that, Mike?
Yeah, I do. Let's see. It's on 2 pages, right? 2 separate sheets?
The elevations are, but there was another one that showed the percentage for the windows.
See, that queuing.
3.1 maybe?
Now there's 3 things. So it's a bit like take your turn kind of a thing?
I got, yeah.
Is there a gate?
Triple zipper.
How was that
Is there a
addressed?
little light that says?
I wasn't
"Okay,
here
your
at the
turn"?
last meeting. How did Tommy's address that?
Trails one.
I could see 2.
Because they got approval.
3 lines.
Oh, here's the one with the.
To be honest.
You can't even zipper merge, let alone
You know,
triple
I
zipper
have a
merge.
dumb- I have another dumb question.
No such thing.
Based on your queuing schematic,
I can't believe
it looks
they-
like you have
they
3
bought the
lines.
property.
That is correct, yes.
And they're supposed
All the way
to
through
alternate.
to get approved, and then they never
Is
did
that
it.
my understanding?
A lot of money.
The people don't choose to alternate yet, but yes, they do alternate.
Okay, so I can understand 2 lines alternating, but I'd like to be the circus guy that's gonna watch 3 lines alternate. That's gonna be interesting.
They have gates, don't they?
Do they get like a green light and 2
There's
red lights?
gates. Yeah.
Oh,
Oh,
there's
there's
gates.
gates. Oh, there we go. I feel better.
There we go. All right, perfect, excellent. Mike, you want to go back to your screen?
Can you bring up what's on the computer?
Here we go.
Thanks.
All right, excellent. So there you go. So the top one would be the east side. That's the entrance. That one's 27%. And then the next one is the 22 side, which is 19.8. And then the 17.73 is the exit on the west side of the property, and the 20.07 is the northern one. So essentially, we're at 20.7% of the total square footage of the face, which is greatly improved from the last one. We were at like 6 and 3, I think. So, and then also with that, there was also a discussion related to the building materials itself. We would like the Planning Commission to still consider large CMU block that is colored. So I just wanted to see if there's any discussion related to that.
What color?
Mike, you want to pull back up to those renderings? It would be very similar to that one.
That one.
Yep, that one right there.
Over the vacuum.
So what is the material there again, sir?
So it's brick on the entrance and the exits, and then it would be colored CMU block everywhere else.
Don't we require a offset every so many feet?
There are variations in the building walls. You just can't see it in that rendering.
So when you say plain CMU block, what?
It would be a textured block. Obviously, it wouldn't be the flat block, but it would be textured and painted.
Split face.
Colored.
Split face, yeah.
Yes, that is correct.
Okay.
Does it say anywhere on the drawings themselves what is brick and what is split face block?
Yeah, so if you could zoom in a little bit, Mike. The red color is the brick, and then the tan and the lighter color would all be block.
Split face block.
That is correct, yes.
Does it say that somewhere?
What does it call out specifically on the drawing?
That one may not be, but I do have other ones that I can show you that calls out the split face block.
Okay.
And those
Been
ones.
submitted?
Yes. Yep.
Okay.
Okay.
Is it integral color in the block, or is it just on the face?
Oh, it wouldn't be painted. I think the whole block's colored. I'm not sure how that works, but I would assume it's integral in the block itself.
I'm pretty sure it's integral through the block. I mean, I'm sure you could paint them, but
Yeah,
the
but
ones
I would
I've
think
seen, the
you'd
ones
want
I've
it
seen, the
integral.
whole.
Right.
The whole block
units
is
colored.
colored.
And it's
Yeah,
colored.
Yes.
Yeah.
That's what you prefer.
Yes.
Yeah, and that's what I've seen in those blocks. I mean,
Okay. All right, boys and girls, what is your pleasure here?
Mr. Chairman, real quick, there were some waiver requests. I don't think that got brought
yeah.
up.
Did we talk about them last time?
I think they may have been brought up. It was the same waivers that were granted for the Tommy's Car Wash.
All relative to narratives and statements.
I think it was that.
All of the pertinent ones related to the development itself. Those were all provided and submitted, but there were, I think, a handful that were not.
Like the hydrogeologic study, I forget the other 2 or 3.
Isn't there it's been submitted in writing?
The waiver request, yes, they were
Yes.
included with the original application. All of the same ones that were previously approved. Every other study that was not requested for a waiver, we provided those studies.
Okay.
are they all related to studies? The waivers?
The waivers, yes.
Okay.
Yep.
All right, so the only thing that we would have as conditions would be PennDOT, or you said you had the Westmoreland County Conservation District approval?
It's submitted, we resubmitted a week and a half ago, administrative comments. We're still in the
We
process.
still need that, and the stormwater management plan, has that been?
It's been reviewed by the municipal engineer. There were, I think, one comment related to drawdown time, and we'll provide that in our resubmission back to them to ensure the water's in 72 hours, but it's not an infiltration and it's underground. So.
Okay, so 3 things.
And I have the waiver request up if you want to know what the three are.
It's there, it's already been submitted.
It's supposed to be 0.0 at the property line for lighting, correct?
Yep.
I see a 0.4, I see a 0.5. 22. I see a 0.4. I see 0.2 in the Old William Penn Highway.
Could you go over your lighting plan with us for a second, sir?
I can, yes.
Sheet is that?
C310.
Yes,
It's
310.
on C310,
Yep.
dated June 2025.
Is that the township submission set?
Yeah.
Yes, sir. There are no variances requested, so I have to assume that driveways are not required to adhere to the 0.1 at the property line, although there are some 0.2. So I'm not quite sure exactly what the lighting level requirement is, but these were submitted to our consultant for design to meet the
Supposed to be
ordinance.
0 at the property line.
We've got a 0.5 on new 22, 0.4, couple 0.4s, couple 0.3s.
Who is your lighting consultant, sir?
LaFace McGovern.
And if I look on this C310, where are the lights? What color are they?
They're not in color. There is, actually, there's none at the driveways anyways, but there are two just north of the vacuum spaces. That's the line between 2 and 3 and between 7 and 8. There are building mounted lights. There is an area light beside the trash enclosure, one in the middle of the 5 parking spaces on the left, one across from the driveway into the queue lanes, and one at the queue lanes itself, as well as one coming out of the order points.
So the ones on the north side there, the 0.6 on the driveway and all, I think you probably, because there's,
That needs fixed.
pardon me?
That needs fixed.
Yeah, it needs fixed, but I think you could do that, accomplish that with some shielding.
Correct. Yeah, if there's a revision that needs to be made to meet the ordinance requirements for the lighting plan, we can do that.
Yeah.
Can make that up.
0.0 at the property line.
Yeah.
What are the hours of operation for this unit?
7 to 7.
And is it lit 24 hours?
Not fully, like there will be some building lights on, but no, it's not.
Probably minimal security lighting it.
Right.
Correct, yes.
Okay, so that would be another condition of approval that the lighting plan needs revised.
Yes.
What's the other conditions, Bob?
HOP.
PennDOT permit, lighting.
PDS, FTMS.
Well, they got, it's not an NPDS permit, it's just, is it an NPDS?
It is, yes, yeah, we're over an acre.
NPDS permit. And approval from FTMSA.
That's correct.
Have you submitted your planning modules yet?
We're working with FTMSA on taps that are allocated to this. There was a car wash that was previously recommended for approval. It's not in service yet, so they're looking at reallocating those taps to this project, but that we're working with them directly on that.
Waiver.
So we have.
Waiver requirement.
And approval of, recommend approval of the waivers.
Yeah.
Okay. Mr. Chairman, I'm going to make a motion on CU 325, SP 325, SP 3, no, S 325, Drake's Car Wash. We forward this to council with our recommendation for approval with the following conditions: that the waivers be accepted by council. We need a revision to the lighting plan so that it's 0.0 at the property lines. We need the HOP PennDOT permit. We need an approval for the NPDES, and we also need approval from FTMSA. Did I miss anything?
That's it.
I think you got it, Jay.
I'll second that.
Second. Any question on the motion? Hearing none, all those in favor say aye. Aye. Opposed? Thank you.
That was the recommendation for all three applications, right? It was all
Yes,
joined in one?
yes.
All right, perfect. All right, excellent. Thank you for your time. Appreciate it.
Thank you.
Y'all have a good evening.
What's left of it?
It's got off easy tonight, it's only 2 hours.
When's that approval for 10% raise coming through?
Yeah, well, that's,
10% is zero, still zero.
yeah. Is there any other business before us, Mr. Wozniak?
Not tonight.
What do you got in the hopper?
What's going on, what's going in at Atria's? Everybody's asking.
I heard pizza place.
I'll tell you off mic.
Huh?
I'll tell you off mic.
Okay. That works for me. I make a motion, we close?
We adjourn, second. All those in favor say aye. Aye. Opposed? Thank you.